Hi, this is Mustafa.
Hi, this is Leo.
Hi, I'm Belinda.
I am Darren.
And this is our video assignment for Criminal Law 2. Thank you.
Hello, my name is Umar Abdullah, and before proceeding to compare the laws in relation to child marriages in both jurisdictions, whether it was the United Kingdom or Malaysia, it is fundamental to know the definition of a child marriage. A child marriage is defined as a marriage of a girl or a boy who are below the legal age of 18, and it also refers to both formal and informal unions in which children under the age of 18 will live with a partner as if married. Child marriages violate children's rights, and there are three cons to child marriages. Firstly, it makes the child vulnerable to violence, and secondly, it makes the child vulnerable to exploitation, and thirdly, it also makes the child vulnerable to some cases of abuse. Child marriages are huge taboos in most areas around the world. And that is mainly because a child that is under the legal age of 18 does not comprehend nor understand the nature of marriages. Meaning that the child is basically forced to get married. However, the fact that a man that is going to be 10 times the girl's age is going to engage in some sort of sexual intercourse, this has many negative aspects to it, which is going to affect the girl or the child in many ways. These ways are of three. The first main type is whether it was socially, physically, or mentally. And still, the family of such children do not have the logical understanding of the dangers of child marriages. Ironically, it may come as a surprise to learn that the United Kingdom, which is presumably one of the most developed countries in the world, does not have legislation which criminalizes the child marriages. The only laws in relation to child marriages is the fact that certain marriages will be considered void. This is found in Section 25, Section 1 of the Marriage Act 1949, which states that, and I quote, "A marriage shall be void in case any person knowingly and willfully intermarry according to the rites of the church. It will be void if it is done in any place other than the church or other building in which bans may be published. Without bans having been duly published, a common license have been obtained, or having been duly issued under Part 3 of this Act by a superintendent, registrar, to whom due notice of marriage has been given, or on the authority of a publication of bans which is void, or in any case of a marriage on the authority of a superintendent registrar in any place other than the church." As mentioned in Section 25 of Section 1, there is nothing which deems child marriage as illegal in terms of child. Therefore, from the understanding of what has just been mentioned, it is clear that there are no laws which criminalize the marriage of child marriages, and there are no laws which punish a man who is going to marry a child that is under the legal age of 18 or 16. However, as mentioned, these marriages will be void. But this man will not be punished, meaning that there are no laws which criminalize such acts.
Hi there. So, having understood the principles and also the workings and position of the United Kingdom on the mentioned topic, being Malaysian, it's also very important and paramount for us to understand how marriages, and especially when children are concerned, is in our own country. Zooming into Malaysian law, a child under the Child Act of 2001 is defined as anybody who is below the age of 21, which 21 is the age of majority. Now, moving forward, there is a certain group of people that says child marriages are okay due to its nature, but we, being a modern society, we argue otherwise. Now, the latest consensus show that in Malaysia, the number of child marriages are of a rise. And also statistics based on UNICEF says that child marriages are in a steady linear increment across the board. Now, as many as 15,000 child marriages have been recorded. Now, females or ladies at the age of 16 years old are able to get married as it is, as long as they get the consent from their parents. Now, this, however, is in the case and also in the situation whereby the bride is 16 years old. Now, however, for the male has to be above the age of 18. If we talk about Islam, the bride can be much younger due to Islamic laws which are governed by the Islamic Family Law, Federal Territories Act 1984. Now, there is a need to amend the current laws as the Law Reform Act of 1976, which governs marriage in general, can be said slightly flawed and also does not set a limit towards child marriages. However, this is being changed as a bill to amend the Law Reform Act is being tabled in 2019, spearheaded by Dr. Wan Azizah. Now, having Malaysian laws pretty tough to amend and also due to its procedures, having to table a paper in Parliament and having a majority decision to pass the amendment, it's not easy for laws to be changed in Malaysia. Now, having this, we are quite thankful that we have some modern and also forward-thinking judges in the country that they are still abide and they also still have to abide by the laws and acts written by and passed by Parliament. But we're pretty lucky because at the end of the day, it's all interpretation. So judges do play an important role in helping to prevent and also helping to curb and tighten the amount of child marriages we have in the country. Now, furthermore, another reason that proves that child marriages are bad is the government is slowly taking steps to further tighten and also raising the age of marriages. Now, currently the government has only been successful in raising the age of marriages in one state. Now, that is our home state of Selangor. Now, with this, Selangor has set and also positioned itself as a trailblazer, and also other states has also proved that they want to raise the age slightly higher. Now, Selangor has become a trailblazer for such states as Malacca, Penang, Kedah, Johor, and Sabah, which they plan to slowly implement a higher age of which marriages should be attained and also to totally ban child marriages all in all moving forward.
There is no publicly government data on child marriage in the United Kingdom. However, we should not assume that child marriage is not an issue in the United Kingdom just because it is one of the most developed countries in the world. In the United Kingdom, the Marriage Act 1949 and the Matrimonial Causes Act 1973 together constitute the law on marriage in England and Wales. However, these legislation do not protect child from forced marriage. As mentioned by my teammate Omar earlier, the legal minimum age of marriage is 18 years old in England, Wales, and Northern Ireland. Nevertheless, marriage is still allowed for children who age between 16 and 18 with parental consent. Some parents use these legal loopholes to force the marriages of their children who age 16 or 17. According to a journal written by Aisha Gill and Sundari Anita, forcing children to marry violates Article 12 of the European Convention on Human Rights. The article declares that men and women of marriageable age have the right to marry or to found a family according to the national law governing the exercise of that right. We can look into the case NS versus MI to see how child was tricked into marriage. In this case, victim was tricked into traveling abroad on the pretext of a holiday has been arranged. Unknown to the victim was married when the victim arrived the destinations. It is very difficult for a young person to rebel when he or she is in a strange place without financial resources or a passport. as usually parents would confiscate their passport on arrival in the country. There is no one to whom the child may turn to for help, as the community is in this together with the parents. According to Danning Law Journal, it is shown in a study which centered on Luton, a town with high immigrant populations, found that more than 200 forced marriages reported to various authorities. Dr. Nazim Khanum, who was responsible for the study, has suggested that the real number of forced marriages in the United Kingdom is likely to be closer to 4,000. Victims are primarily Muslim women from families of Pakistani and Bangladeshi origin. According to Girls Not Right website, the United Kingdom has committed to eliminate child, early and forced marriages by 2030 in line with Target 5.13 of the United Nations Sustainable Development Goal. In 2014, England and Wales criminalized forced marriage under the Anti-Social Behaviour, Crime Policing Act 2014. Now, forcing children into marriage is liable to a maximum of 7 years in jail. The Act also criminalized forcing a British national into marriage outside of the UK. In 2008, the Forced Marriage Civil Protections Act came into force along with Forced Marriage Protection Orders, which intend those threatened with forced marriage or by a third party on their behalf, and can be used to prevent forced marriages taking place or to protect someone who has been already forced into marriages.
The Sexual Offense Against Children Act failed to address one of the weaknesses, which is underage marriage, child marriage, even though the Act has covered new offenses against children, for example, child marriage and child pornography. However, the Act did not really touch on child marriage. The Malaysian Islamic Family Law, Act 1984, concerning the marriageable age for women is lower than men. Under Section 8 clearly states that the minimum legal age for Muslim boys to marry is 18 years old, while it's 16 for a Muslim girl. Younger couples are allowed to get married by a written permission from the Sharia court after both sets of parents have put in application to formalize their nuptial. Without permission from the Sharia court, the couple has committed an offense and shall be punished with a fine not exceeding 1,000 ringgit, or jail not exceeding 6 months, or both. For non-Muslims, the legal age for marriage is 18. Non-Muslims girls are permitted to marry between the ages of 16 and 18 with the consent of the chief minister. This is clearly provided under Section 10 of the Law Reform Marriage and Divorce Act 1976. Act 164, although the law on this issue looks clear, it can be abused if no proper action is taken. The Law Reform Marriage and Divorce Act stipulated that under no circumstances can the marriage of non-Muslim below 16 years old be legally approved. Critically, Muslims are exempted from this act, resulting there is no written absolute minimum age for them. Due to the fact that children are being forcibly and out of the blue exposed to sexual marriages before they are physically and emotionally ready, the girls are at risk of bearing children before their bodies are physically mature for it. Even though an approval from a Sharia court judge or a chief minister is required to allow a child marriage, nevertheless, this reliance on this discretion of the judge has raised many concerns and worried many people, because based on the approval rate of children marriage application, according to the JKSM data in 2015 was 81% child marriage application, but the approval may become a mere procedural process. Even though there are laws that in regard to such situation, unfortunately, immoral parents can easily manipulate to marry of their daughters. When sex acts or abuse have occurred and processed off with the consent of the parents, the court have no any power or decision on the matter, but rather to agree to the marriage. The court must be more responsible and more willing to exercise its power and decide by themselves the best course of the action to protect the child from being sexually abused behind the coercion of marriage, rather than submitting to the family's pressure, as it is the role of the courts to protect people even from their parents in this case. Many solutions are recommended. Firstly, is to reform the approval process by allowing objections by a child's relatives or a government officer above a certain rank in the welfare department, or a social worker with a demonstrable and reasonable and eventual ground for objection to stop such traditional practices. If there is a slightest clue of sexual abuse and opposition by the child, the judge or the chief minister ought not to accept the application and instead of that order a police investigation. Hopefully in the future maybe the sultans or the state heads discuss and apply some pressure to put up a minimum age for child marriage, introducing compulsory education on the effects of child marriage. And the government should consider this proposal, meet agencies on the issue, and find ways to protect the interest and the safety of the Malaysian children, either Muslims or non-Muslims. But in this case, it's Muslims. An underage marriage has an enduring consequences, especially in the victim, the girls in this case, women married in their teens, where as a result of that, it limits her opportunity for empowerment and social development and increase her risk of exposure to violence and abuse and struggle with the health effect of getting pregnant in very young age. The welfare of the newborn is also uncertain. Lastly, underage marriages might result to a domestic violence, child sexual abuse, and even marital rape if no serious steps are taken to stop this.
Child marriage among Muslims in Malaysia is a complex issue. The driver largely involves socio-economics and sexual and reproductive health factors, so addressing these root causes will be productive in the long term. The Sharia court can be actively involved in the effort to prevent child marriage. The main weakness in the Sharia court system is the absence of a standard operating procedure, unify and standardize the application process for child marriage without proper consideration. In civil law, while the government of Malaysia is committed to providing the rights of the children, the intention has yet to be fully manifested in the form of statutory provision that empowers conventional rights to have legal effects as well as to be enforceable in the court of law. It is unfortunate that there is no specific provision on preventing child marriage under the Child Act 2001, even though it violates the fundamental rights of children. With its plural society, Malaysia provides different legal framework for Muslims, non-Muslims, the Bumiputra of Sabah and Sarawak, and the Orang Asli of Peninsular Malaysia. This has created different legal conditions while dealing with child marriage. Therefore, as a first step forward towards addressing the resulting gaps, a clear minimum age for marriage that is in conformity with the international standards, which is 18 years of age, must be set in legislation for all legal systems. It is therefore urged in the light of Malaysia and international and national commitment that the minimum age of the marriage is set in 18 in all legal frameworks alongside the above recommendation. And to this extent, urge legal reforms to be recommended as a part of solution to ending child marriage in Malaysia.
Thanks for watching.